Yes, welcome to the long-awaited edition of the No State Project called The Anatomy of a Frivolous Argument. I've been talking about it for a while. I'm glad I'm finally able to get this posted. So, Anatomy of a Frivolous Argument. What we're going to be talking about and dissecting exactly what a frivolous argument is. So, anybody who's ever gone to court, especially in dealing with tax agents and tax attorneys, when you make your arguments, they're typically just going to be shouting frivolous, 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 as if they're being paid by the word. And so what we're going to do is we're going to break this down, okay? I've spoken about it a lot. I just figured a formal analysis was worth doing, especially if you are new and to the court system and want to learn how to more effectively defend yourself. And just how to, and this will also just help, even if you're not involved with something like that, just help you break down an argument or explain an argument better, especially to debunk an argument. All right, let's just dive right into this. The typical frivolous, when I'm accused of a frivolous argument, that's what we're going to be going through in this video, an actual argument that I wrote against the Franchise Tax Board. And it's basically that the Franchise Tax Board or the Internal Revenue Service, that their foundational claim that just because I'm physically in California, that that their laws apply and create obligations to file tax returns and pay taxes. That's their foundational claim. And then when I make a statement of fact or argue that by their own admission they don't have any actual evidence to support their claim, then they start screaming frivolous, 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 frivolous. So what we're gonna do is just break down and see if the actual argument itself, which is more just a statement of fact, is the actual argument frivolous or not, and the implications of that. So, what we have to do first, we have to examine exactly what is a frivolous argument. Is an argument frivolous because it has no merit? Well, if that were true, then in any court proceeding, half the attorneys would be getting sanctioned for frivolous arguments because their arguments are being rejected. So it's not that. So we have to find out exactly what it is. So I have I'll have posted here, of course, the court cases, and also that'll all be listed in the article that goes with this video. But there are usually just two constants. Okay, just because a motion is denied or an argument is rejected by a tax court judge or a traffic court judge, which just rubber stamps the prosecution, like the tax court, like a judge in a tax proceeding. Here we have an appeal or an argument is not frivolous just because it has no merit, and that's one of many, many cases that say that. So we're going to go to Ballantyne's Law Dictionary, which I know is a secondary source unless it's quoting a court case, which makes it a primary source. Frivolous. This is Ballantyne's Law Dictionary, 3rd edition, page 503. So clearly and palpably bad and insufficient as to require no argument or illustration to show the character as indicative of bad faith upon a bare inspection. That's Strong v. Sproul, 53 New York, 497. The quote is actually on page 499. Black's Law Dictionary is adding to that with an expanded definition from Strong v. Sproul, where it does not, a frivolous argument is one that is lacking in merit, brought in bad faith, and where it does not controvert, very important, it does not controvert the material points of the opposite pleading, and is presumably interposed for mere purposes of delay or to embarrass the opponent. So now we understand a little bit better what a frivolous argument is. So it's three basic elements. One, it lacks merit. Two, it doesn't controvert the material points. Three, it's brought in bad faith. Now, this is indicative, of course, of when an attorney, for example, who we'll get into a little more in just a few minutes, who screams it's a frivolous argument and knows it's not a frivolous argument. See, attorneys can't claim that they don't understand what the word frivolous means. Any attorney should know, and it should be held to the standard that a argument that is wrong or ultimately rejected by a court is not automatically frivolous. It has to have these three elements: lacks merit, doesn't controvert the material points, and is brought in bad faith. So let's look at the argument that I usually have and see if it meets this criteria. Again, this is directly from a Franchise Tax Board appeal to the Board of Tax Appeals that I wrote. So the legal claims made against me have no factual support. The FTB, or the Franchise Tax Board, knows this and is proceeding against me anyway. Now, the legal claim that I'm referring to here is the claim that the laws apply because the target of the assessment is physically in California or has a California source of money. The FTB themselves, which is why I make these calls, they're the ones who tell me what the foundational claim is. I know what it is. I just ask them to confirm that, and once they do, then I start asking if they can actually prove that, which of course they cannot. So where I'm getting the statement directly from a Franchise Tax Board or IRS employees, whichever the case may be. And so linked in the article will be a video that has an actual Franchise Tax Board call for this particular case, where the agent confirms that that is their foundational claim. If you have a California source of money, boom, the laws apply. When asked for facts to prove that that was true, he was backed into a corner, couldn't do that, and agreed that it was an assumption. Their foundational claim is an assumption, okay? Doesn't matter how popular it is. That has nothing to do with its accuracy or its veracity. It's an assumption. That's what's important. The foundational claim is not based on facts. It's an assumption. So now let's go through our 3 prongs. 1, does the claim have merit? Well, it's based on facts. It's based on verifiable facts. So yes, the FTB and the IRS operate under the same presumption, and they admit it. So we're using their admission. They claim the laws apply because I'm physically in California. It's not my claim, it's theirs. And their foundational claim by admission is an assumption. So the argument, if it's an argument, if I am going to actually argue, is based on their admission. So here we can see that the facts are they claim that that's their foundational claim. They confirmed it. They admit that it is an assumption. So by their own rules, they are supposed to have facts. So the Franchise Tax Board and the IRS both have to have their foundational claim supported by facts, or it is called a naked assessment. And so the United States Supreme Court, for U.S. versus Janus, 428 U.S. 433, the determination of tax due then may be one, quote, without rational foundation and excessive, and not properly subject to the usual rule with respect to the burden of proof in tax cases. So that is the basic legal principle. So we have our facts, we have their admission that this is their foundational claim. If you have California source money, the laws apply. We have their admission that that is an assumption, not based on fact. So the argument is based on the facts that we can prove and a solid legal ground. Okay? So the argument has merit because it's based on a sound legal principle supported by the agent's own admissions. And there are California State Supreme Court cases that echo that they have to have evidence. Number 2 of our 3 planks, or 3 elements of a frivolous argument is, does it controvert the material points made by the Franchise Tax Board or the IRS? Well, yeah, by their own admission, we're addressing their own, the foundational claim that they confirm. And you hear on the call, they confirm it. You can call yourself and they'll confirm it. By their own admission, they operate under that presumption that if I'm physically in California or I have California source of money, the laws apply and create an obligation to file a return and pay taxes. And yet, that is an assumption. So the argument that that is their claim and that they have no evidence by their own admission directly controverts the point. I'm dealing directly with it. So it's logical and it's consistent with the facts. So those are 2 of the planks so far. So the third one is it brought in bad faith? Well, it's based on facts. I think it's pretty easy we can see. It's based on facts and a well-established legal principle that they have to have evidence to support their claim. So given that it's based in fact by their own admissions and it's based on it's also based on a solid legal principle, no, there could be no finding that it was brought in bad faith. So none of the 3 elements are there. There is no, the argument may be wrong. I may have my facts wrong. I may be misinterpreting my facts, but that doesn't make it frivolous. It makes it wrong. And as the courts have said, even an argument without merit doesn't automatically mean it's frivolous, because we got 3 prongs there, 3 elements that have to be satisfied. So it's obvious it's not a frivolous argument. So now I just want to discuss real quickly, why do these people insist that it's frivolous? And let's keep in mind, if a lawyer or anyone in court is probably going to be held to the same standard, a pro per is going to be held to the same standard as an attorney. And I agree with, at least in part, with the ethical obligations that lawyers have. So candor towards the tribunal, this should be whether it's in court or whether it's administrative. Lawyers under 3.1, which is the general rule, it's the American Bar Association rule, and it's usually mimicked by the state bar associations. But Rule 3.3 is candor towards the court, that no lawyer or someone acting as a pro per may knowingly make a false statement of fact or law. Now, if they're going to make a legal argument that my position is a frivolous argument, and they have to know that it doesn't meet all 3 of the prongs or elements necessary for a frivolous argument, they are violating the ethical code. And that's something that I would definitely, when you got 3.1 and 3.3, I would definitely make an objection and move for sanctions against them. It's not a frivolous argument. So why? One, why do they do it? Because they can get away with it. So you can make a 3.1 argument that they're lying to the court, that's not, well, we'll get in here in a second about where they actually strawman the position, but they're going to get away with it. They do it to distract and to disparage and to prejudice you. They're doing it deliberately, and we have to object and point it out. I want to know from the attorney, are you telling me that every argument without merit, or it's rejected by the court, is actually frivolous? Is that your position? Because that's not what frivolous means. See, what they're really getting down to here, when you clear out all this, stuff, what they're really saying is frivolous is not the argument. It's not the facts, because they can't show where any of the facts are wrong. So that's another thing. If they say it's a frivolous argument, it's lacking in merit, are you disputing the facts? So you can't have a summary disposition if there is a dispute to the facts. But we don't expect judges in traffic court or tax situations to actually adhere to that. We know that they don't do that. But when they hit you with frivolous, ask them, what set of facts do you have wrong? What facts do you disagree with there? You can even ask, do you disagree with the facts and my conclusion? Or is it just the facts and or the conclusion? Which one is it? Is it all of it? Is it but they do it because they can. And so one of the things that they'll do is they'll strawman, which we talk about on the No State Project all the time, because they never want to address the actual issue, because you cannot sustain logically and validly, honestly, that any claim it's a frivolous argument, because you cannot show the 3 elements. You can't show where the facts are wrong, and you can't show where the facts don't lead naturally to the conclusion, and you can't show that it's not based on a solid legal principle that they have to have evidence. So an example of the straw man is from this court case. It's an administrative law case, which we had to withdraw to avoid the sanctions. Appellant's inquiry is entirely nonsensical, and while we are unsure of the exact import of the statement, it appears to be based on the meritless contention that California does not have jurisdiction to impose a personal income tax on appellant. Now, I've already given the argument. The argument is they do not have evidence by their own admission to support their claim, their foundational claim, when they admit it, that just because I have money from a California source, that the Constitution applies and creates an obligation to file a return. Their own admission. That's the claim. Take issue with that. But they don't. It's called straw man. They just make it look similar, but it's not. See, they try to take just a statement, a legal claim, that has no facts to support it. And in that it's all on the appellant. What they do is they take all the heat off of the franchise tax board who made a baseless claim. And that's what they do. Let's put the focus back on you and keep it off of the franchise tax board's lack of proof. And we know that they're strawmanning. We know what their actual they know what the actual position is because they quote it on the same page. In her briefs, appellant states that she had previously contacted FTB staff and FTB counsel regarding the proposed assessments at issue, and that these individuals failed to provide evidence that the Constitution, which is in quotes, I don't know why, that the Constitution applied to her. So they know what the actual argument is, but they deliberately misstate it so that they can then say it's a frivolous argument. This is what you got to expect. This is the same guy that said that the franchise tax board, this is an administrative law judge, saying that there was nothing that could be done when you have FTB counsel falsifying the record, lying in their brief. Lying. There's no dispute that they were lying. They were lying. Said there was nothing that could be done. At the same time, he's threatening my client with a $5,000 frivolous appeal penalty. Yeah. And just real quick, one of the cases that the administrative law judge uses is called the Appeals of Dauberger 82-SBE-082. It's a California Board of Equalization case, and they cite a lot of federal court cases trying to support their claim that what we raised, which was an issue of fact, was actually a frivolous argument. And so if you actually read that case, and I suggest that you do, that would support that my argument that I wrote, an issue of fact, was frivolous, was these other cases where they were all interpretations of law, where wages are not income within meaning of statute, not a taxpayer within meaning of statute, Federal Reserve notes are not legal tender, and Fifth Amendment prohibits requirement to file a tax return. All interpretations of law, not a single one an issue of fact. Okay? So what it comes down to, and I'll finish here in a couple of minutes, is, like I said, they think the challenge to their claim, their foundational, the challenge is what is frivolous, not the argument, because the argument clearly is not frivolous. That's what they think. That's the real thing that's going on here. They don't like being challenged on their foundational claim because they can't prove it. And if that truly is frivolous under their laws, then that is evidence of a rigged game. Because if they can make a foundational legal claim against us and you can't challenge it, that's not fair. That's not fair even under their rules. So due process requires notice and an opportunity to defend at a meaningful hearing. So if you don't have notice and opportunity to defend because you can't make that challenge because they deemed it frivolous, you are in a rigged game. So, it's not a so-called frivolous argument to point out somebody's foundational claim is admittedly an assumption. At the very least, it is a simple statement of fact that they will not be able to dispute. Well, they may disagree with it, but they won't be able to show any counter evidence. And, we got audio recordings to the contrary. So the argument that the Franchise Tax Board or IRS has failed to support that claim, my argument that the Franchise Tax Board or the IRS has failed to support their claim, the Constitution applies, just because I have money from a California source, is not frivolous. It has merit because, one, it's based on their own admissions. Two, it controverts material points because they admit to not having the evidence. And three, because it is based on a sound legal principle and the FTB's own admissions, there is no bad faith. So regardless of the chance of the lawyers and bureaucrats, the argument is not frivolous. So I hope you enjoyed the video. If you have dissent, if you think something I presented in the video was ridiculous and false, or I just got my facts wrong, my logic is way off base, even if I misquote a case, you're more than welcome to join me on a live broadcast to present your counter evidence or the logic and the reasoning to show where I got an error. Again, my name is Marc Stevens, the website markstevens.net, and this has been Anatomy of a Frivolous Argument.